morning, Mr. Wolffe. Ms. Graham.
Thank you. Good morning. I'd like to go back to something we looked at yesterday, just briefly.
Yes, thank you. I should say there are a couple of points I'd quite like to pick up on from yesterday as well, but I'm happy to take that.
All right. Let's see if they're the same points. Could we look at the letter of instruction that we looked at yesterday, COPFS 00008. This was the letter of instruction to Martin Graves. And we talked about this yesterday. We could look at it's 24th of January 2018. And there was a passage in bold that we looked at yesterday, which I think was on page 2 of this. Here we are. Yes. Given your expertise, the Crown wished to instruct you. Do you see that?
Yes.
And we went through that yesterday. And see the point where it's, so this is the instruction to Mr. Graves, who was the OST or the restraint expert. And in particular, the Crown are seeking an opinion on whether the method of engagement with and restraint of the deceased by officers was reasonable and justifiable, taking into account the requirement for their use of force to be necessary, accountable, proportionate, legal and ethical. And I'd like to ask you about this, the use of this phrase, whether the method of engagement with and restraint of the deceased by officers was reasonable and justifiable. So he's invited to express a view on that. And I want to ask you, reflecting on the use of that phrase, this appears to be an invitation to Martin Graves to read the evidence that's provided, the documentation and such like that's been provided by the Crown to him, and to form his own judgment on the facts, to see whether he thinks the restraint was reasonable. And whether you have any thoughts on whether that approach to Martin Graves is really usurping the function of the court or ultimately the jury in a High Court trial, or whether that is in effect passing the responsibility to Martin Graves to form a view which is actually the function of the Crown, to consider whether there's a sufficiency of evidence from which it would be open to the jury to conclude that the force was not justified or whether it was justified. And I'm interested in your thoughts on whether taking that approach with Mr. Graves is really asking him to decide the issue, which would ultimately be for the jury in a trial. Do you have any thoughts on the use of that approach in this letter of instruction?
I suppose the first observation I would make, and this is born of receiving reports from CAPD in relation to cases of police assault generally, because that was one of the types of case that CAPD dealt with, is that it was, and I can't say whether it was routine in every such case, but I certainly saw other cases where part of the work that CAPD did was to seek advice from someone with appropriate expertise about the techniques of restraint, techniques of the techniques used by police officers in particular situations, in order to inform the judgment of whether force used in a particular case had or had not been excessive. Because if one, so the first point to make is it's not, at least in the experience I had of these cases, by any means unusual or out of order to instruct or to take advice from somebody with experience of methods and techniques of restraint. Why should that be? Well, one steps back and asks, what's the purpose of instructing an expert or allowing opinion evidence to be led in any case? Well, the purpose is to inform the decision maker about facts and circumstances or issues or matters which may not be or aren't of, something which are in the sort of common run of general knowledge. And I suppose the instruction of an expert to give evidence in relation to restraint techniques flows from a recognition that the way in which the police, the methods available to police to respond to particular situations, which may be very various, in a sense, it does involve specialist knowledge in the sense of understanding the different techniques that could be used, understanding what I suppose the current state of the art is in terms of the way in which officers are approach particular situations, understanding the way that officers who've had training could and should be expected to respond to a particular set of circumstances. The fact finder, whether they be a lawyer sitting in Crown Office or whether it be a member of the public sitting in a jury who's never been a police officer, never had to deal with these kinds of situations, may need to be informed about the techniques available, as I say, what's regarded as appropriate and reasonable in particular circumstances. So I suppose that's that's quite perhaps a slightly long-winded way of explaining why I'm not surprised that the Crown was instructing an expert to advise on issues of restraint. And it's also fair to say that it's an interesting point where one gets it with many types of experts. Where's the line between the expert expressing a view on the ultimate issue, which is for the fact finder and the decision maker, and where's the line short of that is providing useful information that can help the decision maker. I mean, I suppose, speaking about expert evidence generally, one would, again, I'm perhaps not, one could think of other circumstances involving issues of negligence and the like, where an expert might be asked to express a view on what was a reasonable course of action in a particular circumstance, even though that's the ultimate question. The important point is that the factual basis upon which the view is reached is robust, or if there are alternative factual scenarios, that's explored and is patent in the ultimate view of the expert, so that the expert's opinion and the basis for it can be properly scrutinized and tested, first of all by the lawyer in the context of a prosecution, and then ultimately tested and scrutinized in court through the process of cross-examination.
I'll come on to the alternative scenarios in a moment.
Yes, and I'm conscious that was one of the issues that you explored with me yesterday. So in terms of the overall the issue in principle of instructing an expert on restraint, that I think is entirely justified and appropriate in a case involving a situation and a set of professional responsibilities that police officers have in a situation which is not the common run of experience of members of the public. And perhaps thinking of, again, a slightly different context, in a professional negligence case, one might well instruct an equivalent professional to express a view on whether what was done was by the defender in a civil case was or was not consistent with what you would expect from a ordinarily competent member of the profession. And although that's the ultimate question for the court, that's evidence that is routinely led and admitted.
Right, there's a lot.
And is helpful. And is helpful.
Yes, so there's a lot in that answer. First of all, in the way that this particular instruction is framed, asking whether the method, the restraint, was reasonable, is that, if you, I think you'd agree, that is really a question for the ultimate fact finder.
Well, I think strictly, I think the question is, was excessive force used? There may be, it's a long time since I looked at the details of the law here, but
we've heard evidence that it is lawful potentially for officers to use force during the course of their duties. But in order for it to be lawful, they can use force, but in order to be lawful, it has to be justified.
Yes.
And that justification has to be vouched for by each officer in relation to each individual use of force by showing that it was reasonable. It was the absolute minimum necessary. It was proportionate. And other less forceful options had been perhaps tried and failed, or were not pursued because it was not appropriate in the circumstances. Yes. So that's the sort of legal framework as we understand it.
Yeah, I mean, as I say, I can't remember numbers, but I certainly saw reports from Cap D, indeed from Mr. Brown, looking at precisely those sorts of questions in the context of allegations of police assault, because I mean, you're absolutely right, in the context of the ordinary functions of a police officer, for a variety of reasons, an officer may require to restrain an individual, they may require to use force, and it's one of the reasons why that question is such a sensitive question, because it's an unusual feature of their role and responsibilities in society that they may be required to do that. And it's not unusual, or not unknown at least, for individuals who are lawfully restrained to view what's happened as an assault and to make an allegation, and that then has to be investigated. And that's precisely the role that Cap D played. So this was a kind of issue which I certainly saw Mr. Brown addressing in other cases in the course of the time when I was Lord Advocate.
So if each individual use of force is not justified by the officer, and whether that be because it wasn't reasonable or there were less forceful options that were suitable but not adopted, then if it's not justified, then it's unlawful use of force. And what's being asked here is whether the restraint by the officers was justifiable, is the word that's used. And that is effectively a decision for the ultimate fact finder, whether that be a tribunal, a jury, or in the High Court, or some other.
Yep. Yeah, no, I entirely take that point.
Now, in asking the witness, the expert witness, to form a view on that, would you accept that that in itself is effectively usurping the function of the ultimate fact finder?
I'm not sure I would use the word usurping, and I recognise that there is a principle of the law of evidence that you don't. I mean, ultimately, the ultimate question is for the fact finder, not for any expert. But as I think illustrate by the reference to the professional negligence context, it's not unknown and indeed perfectly routine in certain contexts for an expert to be asked to give a view on the ultimate question. And then, of course, what's really important is that the opinion is patent, that you could see the assumptions made, that one can test that, and ultimately, if there are conflicting views, the cogency of the reasoning for one position or the other can be tested. That's something that certainly happens in other contexts.
Can we restrict our comments to criminal proceedings?
Yes.
Because this obviously is in relation to the Crown Recognition for to assess criminality, and ultimately this Crown Recognition was designed to look at whether there should be criminal proceedings or not.
Indeed.
And-
but the basic principles of law of evidence are the same, at least as I understand them.
Right. You think the law of evidence in a criminal trial is the same as a civil proof?
Well, I mean, there are lots of specific rules to the
Right.
to the criminal context, with which you and I are well familiar. Some of the basic principles, for example, in relation to the place of expert evidence, are, at least as I recall it, common.
I'd like to focus on potential criminal proceedings, and which is what would be looked at here.
Yes.
And just so those listening aren't confused, you would not ask a road traffic reconstruction expert if the driving had been dangerous.
No.
That would ultimately be a decision for the jury to make. I mean, that would be an objectionable question if
Yes.
that was asked. So in asking an expert whether the force used in a restraint was justified, whether it was reasonable, that would ultimately be a decision for the jury to make, wouldn't it, in
Absolutely.
a trial?
Yeah.
Thank you. Is it possible that taking this approach in the letter of instruction to Mr. Graves would give rise to a risk or perhaps a temptation to hand over responsibility for taking a view on restraint and whether it was justified to the expert, asking them to make that decision, and then simply saying, well, we accept what you have said on that. So to proceed on that, rather than applying your own independent process and thought. Do you think that's a risk?
I can, yeah. I mean, of course, it's a risk, and then one hopes that my mind is applied independently to the, as I say, as one would with all sorts of areas of expert evidence, to the cogency of the explanation, the basis upon which the opinion is expressed, and testing the opinion effectively.
And you, a moment ago, you talked about the importance of the factual position.
Yes.
And we talked yesterday about a factual situation where there were, and it was recognised by Mr. Graves in the body of his report, that there were differing versions of the factual position. And I think yesterday I drew your attention to a part of his report where PC Tomlinson, PC Smith and Mr. Nelson had given statements to PERC about one factual position, and that was that Mr. Bile was lying on his front with PC Walker lying over his upper body. And then there was an alternative and different factual position presented by the statement of PC Walker, where he said PC Walker was on his knees with his upper body over Sheku Bile's right shoulder, with him lying on his left-hand side. And I think yesterday you helpfully explained about hypotheses and how one technique that lawyers can use is to present alternative hypotheses. So the Crown does not say, we pick one version that is correct, but the Crown can explore those different scenarios, as you have said earlier today. So here is one hypothetical scenario that Tomlinson, Smith and Nelson are correct, and they can explore the implications of that factual position. But they can at the same time say, let's now explore an alternative factual position as presented in the statement of PC Walker. And it allows them to look at all the possibilities. And that's what you were talking about yesterday with hypotheses. So this technique of using hypotheses to explore alternative factual positions is a recognised one that lawyers can use to great effect with experts. Would you agree with that?
Well, absolutely, and indeed where there are competing hypotheses of fact, and ultimately one doesn't, as you made the point, ultimately the factual position as it will emerge at the end of a trial, if there's conflicting evidence, there may be different possibilities, and you might explore with an expert what the expert's view was on the different outcomes for which there was a basis, and one might explore. That's, as you say, a perfectly normal process of engagement with an expert in certainly my own professional experience.
And the Crown will look at whether there is a sufficiency, at least on one or perhaps more factual hypotheses when they're considering whether to instigate criminal proceedings. They'll look at whether there's a sufficiency based
Indeed.
on. And looking at that approach, what I can say is in this letter of instruction, there were no hypotheses or alternate hypotheses presented. What we did look at yesterday was on page 7 of 12, where if we could look at that again, in relation to the restraint, which was towards the bottom of the page. There we are. Do you remember we went through this about the Snapchat footage?
Yes.
At the very bottom. From that Snapchat footage, it appears Mr. Byle was lying on the southern pavement on Hayfield Road, surrounded by 5 police officers. A 6th officer, believed to be PC Walker, appears to be lying lengthwise on top of or beside Mr. Byle. So there is a hypothetical, well, a factual hypothesis presented there by the Crown. There's no alternative presented in that passage about the statement of PC Walker, which is he was on his knees with his upper body over Mr. Byle's right shoulder. Looking at that, can you see that the use of hypotheses to address the situation where there are differing accounts, you've accepted that can be a very useful technique. Do you think that's a technique that ought to have been used by the Crown in relation to exploring restraint in this investigation?
I'm conscious this is a letter of instruction, and I frankly now can't recall what subsequent engagement there was with the expert.
I think.
But looking at the issue at the level of principle, it could have been a useful way to explore the issues with the expert, particularly if there were potentially alternative factual positions. But ultimately, the Crown has to take our view on the factual, what the evidential position, and whether that evidential position supports criminal proceedings.
Thank you. I think yesterday I raised with you that we have a note of a consultation that took place with Crown Counsel and Martin Graves, and I indicated that we've not heard yet from APCC, Ashley Edwards, but it did not appear on the face of the consultation notes that the issue of the restraint and the differing versions of what had happened had been put to Mr. Graves in that consultation. And I think I also said to you yesterday that we have also heard that there was a precognition of Martin Graves by Fiona Carnan, and there did not appear to be this issue addressed in the notes that we have of that either. If we can proceed on the basis that this issue was not addressed, or certainly is not in the notes that we have, and subject to hearing further evidence on this matter, if this issue of the alternative hypotheses and an exploration of what was happening in the restraint was not done with Martin Greaves, do you think that is of concern to you, that that issue was not bottomed out, for want of a less colloquial expression?
Well, you put the point to me on a number of hypotheses. I think if I put it this way, I mean, if I were meeting him, I suspect that I would want to explore different hypotheses with him, assuming that there were different reasonable understandings of the facts. But I'm not sure how far I can really go on at the level of abstraction.
Right. And two final points. You mentioned a phrase earlier, and I know I asked you to focus on criminal proceedings, but you talked about asking an expert about what an ordinarily competent member of the profession might do. And is it, as part of presenting a hypothesis to an expert, is it also a recognised technique that you can ask what would an ordinarily competent person, or a person who's complying with all their training and their ethical obligations and their legal obligations, what would that person do, or what is the range of possibilities open to that person in that particular factual hypothesis? Is that also a recognised approach?
Absolutely, even though you might be asking the expert to express a view on what's the ultimate question. It's helpful in terms of one's own understanding of, as you, I think it's implicit in your question, recognise that in many situations there may be a range of responses which are, and I'm speaking again entirely generally, not necessarily to this case, there may be a range of responses which are within the bounds of acceptability. And the question is whether what's been done exceeds those bounds in the context of the particular legal rules that one's looking at.
Thank you. And can I ask, when you were Lord Advocate, was there a training given to members of staff who were engaging with experts, and not just this scenario, but in a number of different scenarios? Because this can be difficult and complicated, dealing with experts. And was there training given to staff to assist them with identifying the right questions to ask and a good approach to take with experts?
I am afraid I don't know whether there was training at that time. I think you showed me yesterday a piece of guidance on engagement with experts, and I made the point that would be guidance directed at staff at all levels. When it comes to experienced Crown Counsel, one is dealing with people with a very substantial amount of professional experience and expertise in dealing with all sorts of evidence, and including expert evidence. That's not to say that any of it, all of us can benefit from training and reflection on our practice, but I would expect experienced Crown Counsel to be well familiar with different ways of engaging with experts, and the nature of the issues that one might want to explore with an expert. And I would also expect an experienced Procurator Fiscal to have also had experience over their career of dealing with experts in a range of contexts. Now, as I say, that's not to diminish the value of training or diminish the value of reflecting on one's professional practice in any context, at any level. We all do that, I hope, all the time. But in this case, I had a highly experienced prosecutor who will have dealt over her career, I would expect, with a wide range of experts in all sorts of contexts, and be very familiar and comfortable with the ways of handling an expert. But you'll have to ask her what she did, in terms of, factually.
So to go back to what we were saying earlier, to sum this up, although I think you agreed you wouldn't ask a road traffic reconstruction expert whether the driving was dangerous, you could ask that expert how would a careful or a reasonably careful driver drive along a road where the speed limit is 60 miles an hour. It's pouring with rain. It's a Thursday afternoon. The road goes through the middle of town and there's lots of members of the public.
Yes.
So you could present a factual scenario and ask how a reasonable or careful driver would drive along that road. You could perhaps even ask if that careful driver would drive along the road at 80 miles an hour with tinted windows and in the middle of a storm. So those are appropriate questions to ask of an expert, which would then provide the fact finder, whether that's a jury or otherwise, with the framework against which they can compare what a reasonable driver would do, a careful driver, and can then consider the ultimate question of, was this driving dangerous? Is that a fair summary?
Yes, I mean, in any particular legal context, there will maybe a wide range of questions that one will explore and can perfectly legitimately explore with an expert, up to and different ways of approaching it in a way which, provide useful assistance to the fact finder, while always recognising the fact finder's absolute, the ultimate questions for the fact finder.
Thank you. I'd like to move on to another issue related to Article 2 compliance and reasonable promptness or delay, but I'm still conscious you said there was one or two matters you wanted to raise with the Chair.
Just a couple of points, reflecting on the evidence yesterday, and I may say I couldn't find the transcript on the website yesterday evening.
Right.
So this is just very much for reflecting on the issues that you raised with me yesterday. Thinking first of all about the points that we discussed, I think, before lunch in relation to questions of subconscious bias and racist tropes, and I think. What that illustrated was the importance of addressing questions of subconscious bias and racist tropes, and the need to tackle those issues where one finds them. I suppose and indeed that those may well be important issues to explore if there haven't been criminal proceedings in the context of a fatal accident inquiry or a public inquiry. I suppose the question that I found myself reflecting on last night was, and I don't have an answer to these, and it may actually support some of the points that we did discuss, but where questions of subconscious bias and plays into questions of criminality. You put to me comments made by officers and statements, and of course, the first question would be, were those statements admissible? And I can't now remember, but you will know whether I think I'm right, but you will correct me if I'm wrong, that at the point of marking the case, the Crown took the view that it should proceed on the basis that the officer's statements against interest would not be admissible. But that's a question that would need to be asked and answered.
We did explore that with Fiona Carnan, so the chair has that evidence available to him.
And as I say, I'm afraid my active recollection is misty. So that's a question one would have to ask. Is that material admissible? And then on the questions of subconscious bias, as opposed to, as it were, an active racist animus, how does that play into the law on the mens rea of assault? Again, I'm afraid I haven't looked up the books overnight, but it strikes me that that's a difficult question, does subconscious bias play at all into questions of mens rea? And if so, in what way? As one adminical among many, is it enough on its own? I would question that. And then I suppose the third possibility is that those issues may play into questions of whether potentially excessive force had been used. And I suppose there, the question that I think one would consider would be whether if, as it were, objectively and without regard to questions of subconscious bias, the methods of restraint used were applying the tests that you gave me a moment ago within the bounds of reasonable acceptability, then does the issue of subconscious bias in the context of a criminal case take you any further? Now, I make those points because not for a moment to diminish the importance of those issues. And indeed, at some level, I think it perhaps supports the proposition that one might want to see that process of analysis worked out. But I make those points because and I'm conscious the decision not to prosecute is not
that's not part of
the inquiry at all. But and I think you recognise in your questions to me yesterday that those issues, there would be a series of questions that would follow, and I just wanted to tease out some of those. And I think one has to. I think it's maybe important just to perhaps make those points that in the context of our criminal investigation, I think there's at the very lowest, a question about where those issues go. Now, reflecting back on it, I entirely recognise that one would want to see that played out in the thinking. And it perhaps goes to support the proposition that it would be better in a case of this sort if one had as it were, a twofold investigation that was looking at issues of criminality and other issues at the same time, rather than the sequential approach which was taken and was, as I say, an entirely orthodox approach to be taken to these questions. And I say that because, of course, ultimately there was a decision not to prosecute. It was reviewed by then Principal Crown Counsel, and I think it's perhaps important for me to say that it's, without in the least taking away from the importance of the points that you were putting to me, that it doesn't necessarily have any impact on those decisions.
We're not wanting to go into the decisions or explore those.
No, I appreciate that. Sorry.
No, I was just going to say that, given what you said this morning and your evidence yesterday, can I sum it up as these are difficult questions, difficult issues, that they should be asked, the questions and the difficulties should be addressed by the Crown, and given careful analysis. Can I say that?
Well, I suppose the question is, if you've taken the view that the statements are inadmissible, then in a sense that and as I say, I don't recall where the Crown got to on that. Then the comments against interest by the officers, as with the points about expert evidence you put to me yesterday, simply fall out of the picture.
I should perhaps say that we have heard evidence about the issue of admissibility from Fiona Carnan.
Right.
And there were a series of questions asked of her, and I think she accepted, and I'm summarising here because I don't have the exact transcript, but she accepted that she'd not set that analysis out fully in her paper, her analysis. She'd not considered the case law, she'd not addressed the test, and she'd within the body of the analysis said a number of things about admissibility. She had said they were not admissible, the statements were not admissible in relation to assessing criminality against the officers, but equally she took into account the statements fully in relation to their justification for the use of force. So there appeared on the face of it to be an inconsistent approach and a failure to address a detailed analysis in light of the case law, yes, or to express a view on what the courts would ultimately decide. So I'm only giving you that information to put your comments into context, but can I also suggest that from what you've said this morning, would you agree that you cannot separate out all of these issues if you are truly considering the whole circumstances, and in particular if you're considering Article 2 and Article 14, racial motive, racial motivation, that all of these issues should be fully and comprehensively addressed by the Crown as part of their investigation?
Can I say I think it's implicit in my acknowledgement that it would be much better if one didn't have an investigation that was focused, as it were, narrowly on the question of criminality at the outset, but look broadly that that one would want all issues to be looked at, and I also entirely accept that one would want to see the questions that we've addressed worked through, and on the question of admissibility, I suspect even though it may not be in the analysis, I suspect that Crown Counsel had a view which would be informed by her own expertise and experience. She's not driven, nor ultimately am I driven when I receive a report from her by what's in the analysis. And equally, if one's going to, if one's wanting to explore whether there's a basis for saying that there was a racist animus that plays into mens rea, one would want to see all those issues explored and thought about. But I suppose there is a point, and we may come back to this in relation to Article 2, and it again, I think it feeds into this question of whether it's wise or appropriate to have a sequential approach of looking at criminality and then other issues. And I accepted yesterday, and I do accept that if it were thought that issues of race should be put to one side until issues of criminality had been bottomed out, then I wouldn't. That would not seem to me to be sound at all. I'm not. I don't know if that. Not sure that was. And the inquiry will form its own view whether that was the approach across all, the whole, all those involved. But the difficulty, I think, in terms of asking the Article 2 question is that the question of whether the state has complied with its Article 2 obligations is something that ultimately one asks when the full process of investigation has been completed, and in this case that of course includes this inquiry. Now that's not to diminish the significance or importance or necessity of the Crown being absolutely mindful of Article 2 and fulfilling its obligation, and routinely its work will, in terms of a criminal investigation, prosecution, potential FAI, will be the mechanisms that fulfill the state's obligations. But I think there are difficulties in as it were, picking one part of that process and saying, trying to reach our concluded view in relation to Article 2 compliance or not, unless one can say that the failure was one which in effect infected, as it were, the whole of the state's response to the particular death.
In terms of the terms of reference for this inquiry, the Chair has an obligation to consider the Crown's compliance with Article 2.
Yes. No, I absolutely appreciate that, and I recognise it's a really important question, and it may, it's something that I think will be of great value going forward. I mean, I took a particular view about the role of the Crown, the importance of the Crown's investigation in Article 2 terms, but I also took a view that if one's asking, has there been a breach of Article 2 by, then one can't put out of account that the criminal process is not the only Article 2 process that will be in place and will be put in place by the state. And indeed, I was acutely conscious of that responsibility when considering the question of what form of inquiry should proceed once the question of criminal investigation had been concluded.
And certainly, in relation to the role of the Chair, he will not be in a position to go back and cure any deficiencies that may or may not have existed in relation to the Crown investigation.
Oh, indeed. And as I entirely accept in my statement, there's the potential for the Crown to do something or not to do something which infects everything, and that's part of the responsibility that the Crown bears in relation to Article 2. But in terms of, and it came into focus for me as the inquiry knows, in the context of disclosure and what the Crown's obligations were in relation to disclosure in the context of a criminal investigation, and whether looking to the Strasbourg case law, one, as it were, looked at the criminal investigation process in isolation, or whether actually the right approach was to consider the whole course of investigation that would follow. Thank you.
In terms of the terms of reference of this inquiry, however, the Chair is obligated to look at Article 2 and Article 14.
Yes. Oh, and that is absolutely. Well, first of all, it's the terms of reference, but secondly, of course, that's that's part of the state fulfilling its obligation under those articles, is the establishment of this inquiry with the terms of reference that it has, and that was one of the reasons for setting up this inquiry.
We'll come back to that. Yes. Just to conclude the issue about the officers' statements and the analysis, I've summarised my understanding, although it's a matter for the Chair, my understanding of Fiona Carnan's position. But in terms, you asked or posed the question, would the statements be admissible would be the first question for the Crown, regardless of any ultimate view taken. But we did hear from Les Brown in evidence in the first week of this hearing, and he indicated that Crown Counsel had proceeded on the basis that the statements were admissible as evidence against the officers.
Right, okay.
So despite the issues with Fiona Carnan's own analysis, that was the way Crown Counsel proceeded.
Okay, well,
As we understand, we've not heard from her,
Yes.
but as we understand the position that on admissibility.
Okay.
So on the basis that those were or may have been admissible, the evidence about language and links to terrorists would have been available to the Crown for use at any subsequent trial.
Well, certainly if they were regarded as admissible, I entirely accept that.
Thank you.
So, but as you say, I think I don't have enough of a clarity in my own mind about what view was taken. So I think you'd need to ask APCC. I should say there's two other brief points just to pick up. One was you asked me a series of points like the one you raised with me this morning in relation to particular pieces of expert evidence. And of course, again, one would need to look at how each of those particular issues played through into the ultimate thinking of the Crown, and whether any particular issue of expertise, as it were, infected in the language you've used, the decision-making process, is something you would have to look at in light of the way it was taken into account in the ultimate decision-making. I have wondered, because you put to me whether I was involved in the suggestion of was it Dr. Lawler?
Dr. Loy, the forensic
and I gave you an
pathologist.
example from my own experience of, and these were complex civil cases where, in effect, the legal team had a sort of an experienced scientist, in effect, as a member of the legal team, not as an intended witness, who could assist in, as it were, the process of translation of the expert material to the legal team. And I have wondered whether that was the genesis of the idea of instructing
Dr. Lawler.
a reviewing pathologist, but that speculation on my part. I have no active memory of that at all, and that model is not not someone whom one would be using as a witness, but someone who is in effect assisting the lawyers to understand, assimilate, the body of expert material and to test it. And I think the other point just that I did want to acknowledge, since we've been discussing the role of APCC, is that of course ultimately she reported the case to me, and I had the opportunity to look at the material, to discuss the case with her, and ultimately approved her decision. Now this, given the scale and complexity of this case, it would have been, I'm afraid, unrealistic for me to, in effect, remark the case, and I cannot now recall what I read, looked at, or indeed the terms of the discussion that I do remember that I had with APCC. I read enough clearly to be able to have some form of intelligent discussion with her, and that discussion resulted in some further work being done on restraint. Again, I'm afraid the detail of which I cannot now remember, but I think it is important that I acknowledge that and put that firmly before the inquiry, as the inquiry already has it.
Well, in fact, touching on this issue is something I was going to go into.
I thought you might, yes.
So could we perhaps look at Ashley Edwards' inquiry statement?
Yes.
And we'll begin with paragraph 10 of that. So this is SPPI 00445, paragraph 10. And I'll just read through this, if I may, to give some context to what I'm going to ask you.
Yes.
I've read my email to Mr. Brown. I reported with my draft CCI, so that means Crown Counsel instruction, to the Lord Advocate on the 1st of June 2018. So this is around 2 years after you've come into the position of Lord Advocate. This was partial CCI and dealt with the cases against the individual officers. So that, as I understand, was the issue regarding criminality in relation to the officers. I forwarded my second draft CCI to Lord Advocate on the 19th of June, so around halfway through that month. There's a second CCI. This dealt with the health and safety aspects of the case, so that's a separate matter. The Chair has evidence available that there was a second supplementary recognition on the health and safety elements. I sent a further supplementary draft CCI to the Lord Advocate on the 22nd of August. So this appears to be a third draft CCI sent the following month, following my consultation with one of the experts. We've not heard from Ashley Edwards yet, so we've not got the full picture here. I issued my CCI, so no longer a draft, a CCI, on the 26th of August 2018. So that appears to be a final CCI, Crown Counsel instruction. By the time of this email, I had completed all of my reading and research, including all the consultations with all but one of the experts. In advance of issuing my final CCI, we were looking at potential next steps. I am not sure about, if we can move up, the paragraph that he's specifically being asked about. From the email, I understand that concerns whether there should be an FAI or whether the circumstances may be better aired in the form of a public inquiry. The investigation looked at all potential criminality. That meant that we were looking at all those involved in the restraint, post-incident actings and the police service of Scotland as a whole. So if we could go up again to the top of that paragraph. I'm interested in a number of elements of this, and I'm hoping you can help put some context around this. This process of a series of partial Crown Counsel instructions followed by a final Crown Counsel instruction, is that now the norm, or was that the norm in Crown Office when you were Lord Advocate? Or the norm where there was an allocated AD?
It wasn't at all unusual for cases to be reported to the law officers for one reason or another. And there are conventions that certain types of cases are routinely reported to the law officers. Normally that would come with in the shape of a report, written report with a recommendation, and the law officer, whether it be myself or the Solicitor General, would consider the report, the recommendation, look at such material as what one needed in order to address the question and respond. I think the practice was certainly that, as I recall it, that the CCI would be issued by Crown Counsel, notwithstanding the case had been reported to the law officer. I don't recall a practice of, as it were, draft CCIs followed by final And I I have to confess, I remember, and I think I do cover this in my statement somewhere, I do recall receiving a report from APCC, and then, you know, having the opportunity to discuss that report with her, and then some further work being done before she, and I think the documentary material I was shown and able to review in advance of the inquiry supported this. You know, before she came back with some further report, and I approved the marking of the case.
So in relation to this approach, do you recall having one meeting with APCC to discuss a number of draft CCIs? And I don't want to ask you about the discussion, but was there one meeting? And if so, when was it in relation to this series of instructions?
I don't know if you're able to point me in my own statement to the point where I deal with this. Because I think that's probably
I'll get someone to find
the best
that
place.
paragraph
That will be the
number.
best place to.
Okay. We'll come back to that aspect.
Yeah.
So, but from your own recollection, was it one meeting that you had with Crown Counsel?
At that stage, I remember. I remember having a meeting with her. Following receipt of her report, I think, and again, I think some time passed before I met with her. Then I think there was some further work done, and the case was further reported. Whether there was a further meeting, I can't remember. Whether in fact there was more than one meeting, I'm afraid I simply can't remember.
So looking at the screen, it says in the middle of the paragraph that we can see on the screen, I sent a further supplementary draft CCI to the Lord Advocate, that would be you at the time, on the 22nd of August, after my consultation with one of the experts. And earlier you said you'd had a discussion and asked Crown Counsel to go and do some further investigations.
Yes. I think that is covered in my statement, so
Right.
if somebody could just
Right.
direct me to the right paragraph, I'll be able to give you the answer straight away from the material that I was able to review ahead of, in order to prepare the statement.
We're in the process of trying to identify the paragraph. We'll come back to
Thank
that
you.
when we get it. In the meantime, you've talked about having the opportunity to look at material. And earlier you said you looked at material and discussed the case. I'm interested in what material were you furnished with prior to your discussion with Crown Counsel?
I think I would have had access to, in effect, the whole file through the Crown Office system. And I don't think I really can't remember. I don't think I had any particular body of hard copy, but I may be wrong about that. And I simply now cannot recall what material I looked at. I mean, I looked at enough to allow me to have, a discussion with Crown Counsel to test her thinking, if I put it that way.
When you say enough, did you have the Crown recognition or access to the Crown recognition?
I would certainly have had access. Well, in both senses, I would have had access to the narrative and analysis, and I would have had access to the underlying material. I think probably electronically through the system rather than being provided with hard copy. But I now can't remember.
Although you can't remember the details, what was your normal practice prior to a meeting with Crown Counsel? Was it to read the entire narrative and analysis, or was it simply to read the analysis, or was it something else?
I mean, it would vary enormously. I mean, there were cases that came to me which would be in where the evidence was in very short compass, where in effect I would, could remark the case. Now that would have been, frankly, impossible in this case, and also not appropriate. I had one of my most senior prosecutors who had consulted with key witnesses and so on. There are other cases, and anyone who's been an advocate depute will recognise this, where I might receive a phone call from an advocate depute seeking my approval for a particular course of action, and where in effect I have probably access to virtually no written material, and what I would do in that case is test the recommendation that was coming to me, ask questions to try and tease out thinking and form a view. In this case, and I'm trying to think. I think I would have read. I expect the narrative and analysis. I think I would probably have read, or at least looked at, some of the underlying material, probably focused, frankly, on the expert material, and I would then have, as I say, I had a meeting with APCC, and we discussed a variety of issues. And my practice, as with the case of the phone call with no papers, would be to sort of test and question in order to seek to identify whether there were things that needed further work.
Do you remember preparing for this meeting with Crown Counsel? In considering the papers that you had available, did you notice that there was an absence of analysis in relation to race? We discussed this yesterday.
Yeah.
Was that something that you were alive to when you read the material? I mean,
I was certainly alert to the background of race. I mean, I cannot now remember. I would be. Well, I think perhaps I could go as far as say I'd be surprised if I didn't ask her about her thinking in relation to the question of whether race played into the question of criminality. But it would be not fair either to her or to anybody else to put it higher than that. And she may have a recollection that I don't have. I think as I say, I think I'd be surprised and disappointed in myself, if I can put it that way, if I didn't ask questions about that aspect of the case, because it was, as we discussed yesterday, clearly a core question.
There's no reference in paragraph 10 that we can see, and I wonder if that question was asked by you, whether race played into the question of criminality, whether you would have invited further investigations in relation to that, as you did with
restraint.
The expert. Was it the restraint expert that you asked? I
think it was specifically in relation to restraint. Right. I think the fact is I didn't. So that had I done so, I'm sure it would have been done.
Yes. All right. So, was there a reason that you can help us with why this approach, where there appears to have been a series of draft Crown Counsel instructions, can you help us understand why this approach was taken in relation to the investigation into Mr. Bio's death?
I think from looking at the materials, and I'm afraid I wouldn't have remembered this without looking at the documents, there was first a report in relation to, as APCC says in her statement, first a report in relation to the officers, and then there was a second report in relation to health and safety aspects, and that's, I think, consistent with the documents that I've seen. As I say, I wouldn't have remembered without seeing them. So that, I think, explains the sequence of, one report, then another report. The fact that the reports came with a draft CCI, in a sense, I suppose that simply reflects the fact that the point of the report was to provide a recommendation to me in terms of the way the case should be addressed, or disposed of, or dealt with at that stage. The fact that it was produced in the form of a draft CCI rather than simply a paragraph at the end of the report, if that's the way it was produced, I'm not sure that what particularly one might take from that.
You've said you would be surprised and disappointed with yourself if you hadn't asked a question of whether race had played into the question of criminality. We've not had the opportunity of speaking to Miss Edwards at this stage, but if you did not ask about race and whether it played into the question of criminality, and if, as it appears, you did not ask for further investigations or further consideration to be given to that question, in light of the questions I asked yesterday about race, Article 2 and Article 14, and your evidence about that, if you also did not ask about race, do you wish to reflect on your own role and comment on any of that?
Well, indeed. I mean, I suppose the first point, at least at the point where I'm having a discussion with APCC, is that I can't remember what I looked at. I may or may not have had access or looked at the statements and those issues. I would be coming to the case, with the narrative and analysis as the sort of the first document and APCC's report, and I'm afraid I don't think in the papers I was shown that I had that, so I can't recall what the focus of that report was. It may be that what I would ask her would be I would in effect be looking for reassurance that she had considered and had thought about whether the evidence that I certainly had been aware of, that one of the officers had expressed racist remarks in the past, whether that played into the decision at all. Whether I would have had, in a sense, in my mind, the material to go beyond that, I simply can't now say. Now, certainly, as I reflect back on the whole course of the material, I think it was perhaps a missed opportunity, not at an early stage in the investigation, to examine the question of how race might be considered and play into the whole case. I think and I would acknowledge that that's a missed opportunity that that ultimately rests with me. I had put in place a very experienced team of investigators. I think it is important to say that my experience of Crown Office was that it was an institution that both internally and externally was very alive to issues of equality and inclusion. I attended staff conferences on equality and inclusion. I was a party to external engagement, and everything that I saw about the organisation would lead me to conclude that it was an organisation that had a very strong ethos, perhaps dating back to the Chokar era, of inclusion and in relation to qualities, both internally and externally. And I guess I frankly assumed that race would be investigated by the very experienced team that was put in place. And I didn't, myself seek to audit that. Now, as I reflect back on this, of course, I can't but regard that as a missed opportunity potentially to have race looked at in a different way. Certainly, as I've come to think about these issues, more recently, for a variety of reasons.
So given your comments yesterday about the importance of race from a very early stage in this investigation, and given what you know about Fiona Carnan's approach to race in the analysis, and if you didn't address this specifically with Crown Counsel and didn't ask for further consideration to be given to it, if, I appreciate you don't recollect, looking back at that now, do you think that ought to have been done?
I mean, it's the fact of the matter, I didn't ask for further work to be done. I think if one's looking back with the benefit of, as it were, perfect hindsight, and now, I mean, you put in front of me a lot of material yesterday that, frankly, I wasn't necessarily cited on when I was engaged in the process of testing and asking APCC about her the reasons for her recommendation. With perfect 2020 hindsight, yes, that was a missed opportunity. There was a missed opportunity to identify an issue and to have that issue looked at in a different and fuller way. For the reasons I mentioned earlier, it doesn't follow that it would have resulted in a different decision. And I think it's quite important remembering that, there are individuals with Article 6 rights as well as individuals with Article 2 and Article 14 rights that one recognises that the question of what would have been a viable criminal prosecution, considered by very, very experienced prosecutors, those issues don't necessarily affect that question, and I know that
and we're not asking you
to
reconsider.
Yes,
that,
it's impossible
that
to do.
decision.
It's impossible to do, and of course that's one of the problems one identifies an issue that wasn't pursued as it might have been or as it should have been. The one can't say how that would have unfolded.
Right. Now, in fairness to you, you asked me to identify some paragraphs in your statement, and I understand it's paragraphs 26 and 27 of your statement, or it may be the ones that you were looking for. This is SBPI 00529, and if we could have a look at 26 and 27. 26, although the Convention about law officer involvement in decisions to prosecute is strictly applied, only where a prosecution was recommended, I envisaged that this case would be reported to me whether or not APCC concluded that a prosecution should be initiated with her conclusions and recommendations, so that I could take or approve the final decision. If at any point during the course of the investigation APCC wished to raise any issue, I would have been available to discuss the case with her. I recall a discussion with her about disclosure, and the documents which have been made available to me contain a reference to a meeting in December 2017, which is couched in terms which suggest that there were other meetings which I cannot now recall. And then if we move down to 27, following the completion of the Crown investigation, APCC did, as expected, report the case to me on the 4th of June 2018 with her conclusion and recommendation. On the 19th of June, she submitted a further report which addressed the question of whether the evidence disclosed a basis for a Health and Safety at Work Act prosecution. This seems to mirror the Ashley Edwards statement. I had a meeting with her to discuss her recommendation. Whilst I do not have a detailed recollection of what was discussed, I do recall instructing that some further work be undertaken, which again appears to be what you've just said. I can see from the papers provided to me that this discussion took place on the 15th of August 2018, and the additional work involved further consultation with the restraint expert and consideration of whether the evidence disclosed a basis for a Health and Safety at Work Act prosecution unconnected with the death of Mr. Bio. And on 23rd of August 2018, APCC re-reported the case to me following that additional work. So this appears to mirror the process that was adopted, that Ashley Edwards speaks to in her statement.
Yes.
And does that help you pinpoint the point at time at which you had the discussion with her, which was the 15th of August 2018?
Yes.
And so that was her draft CCI had gone to you on the 1st, well, it was dated the 1st of June. That was a partial CCI, dealt with the cases against the individual officers. She says she forwarded her second draft CCI to you on the 19th of June. Again, that would have been available to you before the meeting in August. And that dealt with health and safety. And then a supplementary draft CCI on the 22nd of August following her consultation with one of the experts. So it would appear you had two draft CCIs, one relating to the criminality regarding the individuals, one relating to health and safety. You had a meeting on the 15th of August with Crown Counsel, and then further work was done, and then on the 22nd of August a supplementary draft CCI was issued to you after Crown Counsel had had a consultation with one of the experts. So it would appear that you've instructed that further work on the 15th, and then a supplementary draft CCI was sent on the 22nd of August after that consultation had taken place.
Yes, I mean that's all consistent with the documents that that I was able to review ahead of this preparing the statement.
All right, thank you. I'd like to go back to the issue of the incremental strategy that we talked about yesterday. We'd heard about, some called it a linear strategy or a sequential, and Les Brown had given evidence calling it an incremental strategy. So the decision in relation to the individual officers, or the draft CCI, was sent to you on the 1st of June 2018. Although there were subsequent draft and a final CCI, is it fair to interpret from your evidence and the evidence of Ashley Edwards that the issue of criminality relating to the officers had been resolved by June, or at least at the point where your meeting took place with Crown Counsel on the 15th of August?
Well, the investigative work had been undertaken to allow APCC to produce a report to me. She then reports it to me. I instruct, or can't remember just how it would be put, but you know, further work was then done following that meeting, and then you know the decision ultimately is made following APCC's re-report to me. And
So
of course,
towards the end of August,
yes.
that process had been complete.
Yes, so that's yes, and presumably some point after 23rd August, I think the statement. It's maybe the blacked out part. You know, I approved the marking of the case.
So by the end of August, the decision had been made by Crown Counsel, the recommendation had been made, and you had met and approved that, and some
Yes.
further work had been completed, and the matter was concluded in that sense. Can we look at Les Brown's inquiry statement, please? SBPI 00419, paragraph 105. And this is simply to remind you about the incremental strategy that Les Brown spoke about. So 105. And it starts with the passage, a key element of the incremental strategy. There we are. So resolve the issue of potential criminality first, and then it would permit Crown Counsel to take a decision with the necessary confidence, and then permit the investigation to move forward to other areas in anticipation of an inquiry whose forum had yet to be determined. It had been hoped initially the necessary further inquiries could be completed relatively quickly. And then Les Brown went on to say, the recognition was requested and created for the limited purpose of enabling Crown Counsel to take a decision on potential criminality, but it was not intended to be the end of the investigative process by the Crown, particularly in relation to race and implicit bias, and further detailed inquiry would likely have been undertaken had an FAI been instructed. And this would, in my opinion, have been highly likely to have required recognition of the police officers. So there's that process, that incremental, linear, sequential process, with a view to issues of race being explored subsequent to the issues of criminality. And you've said that by the end of August 2018, a decision on the issue of criminality regarding the officers has been taken and approved. Can you tell us what was happening in that period after that decision was taken in relation to exploring these further issues regarding race and implicit bias, and moving on to consider whether an FAI should be instructed?
I can't say whether anything was being done at that stage, because at that stage, I suppose there are two, at least from my point of view, there would be two questions. One is what form of further inquiry would be appropriate, and the other issue, which certainly became looking at the documents, sort of a live issue in my mind, as we approached the meeting with Mr. Bayou's family, was that they of course have a right to review the decision, and so the Crown investigation into the question of criminality can't be regarded as complete unless and until you've had a victim right to review, and that review process has reached its conclusion. And I'm afraid I don't remember the details, but in fact there was the review was triggered, and then Principal Crown Counsel Alex Prentice, under the oversight of the Solicitor General, undertook that review, and my recollection is that itself took some time. So, the Crown investigation in relation to questions of criminality wasn't, as it were, final, couldn't be regarded as final until that process had reached its conclusion.
So were any steps taken from the end of August? We know the VRR commenced on the 1st of February the following year, but were there any steps taken during that period to commence looking into the issues of race and implicit bias at that time?
I'm afraid I can't remember. I would infer, given that Mr. Brown considers that that would be likely to involve recognition for police officers, that may well have been something that was deferred until questions of criminality had been resolved, because as you will appreciate, one couldn't approach police officers for recognition while there was a question of criminal proceedings outstanding.
Leaving aside the position of the officers or prognosing them, do you remember if any steps were taken to analyse the language used by the officers, or looking at the link to terrorism, or any of the things we talked about yesterday?
I've no recollection. I mean, you'd have to ask those who were directly involved in the, as it were, investigative process.
Right. Thank you. Hey, could you give me a moment, please?
Yes, of course.
Would that be inappropriate?
We'll take a 20-minute break at this point. Yes, Ms. Graham.
Thank you. Could we look, please, at paragraph 128 of your inquiry statement? You were asked by the inquiry about any experience you had of racism being a factor in relation to a death in custody or a death following police contact. And you'll see the question actually on the screen as well there, question 62. And you were asked to provide details, and you said at 128, other than in connection with this case, Mr. Bayou, I had, so far as I can recall, no experience of these matters. I wanted to ask you maybe a less specific question. Did you have experience of a case where race was a factor, although it wasn't a death in custody or a death following police contact? Did you have that sort of experience?
Yes. I can give you some illustrations from my professional experience before I became Lord Advocate. I argued on a pro bono basis what I think was the first case in the Court of Session on the public sector equality duty, which was then, it was in a section of the Race Relations Act 1976. It may have been section 71, which concerned the closure of a community centre which was used by ethnic minority communities. In relation to Article 14, I suspect I probably considered Article 14 in a variety of contexts. The one that comes to mind is the Inner House decision in Uganda, which was a case in which I represented the spouse of a refugee who was challenging the Home Office policy which in cases of domestic abuse, granted ILR to indefinite leave to remain to spouses, I think, of individuals who already had indefinite leave to remain. And on behalf of the spouse of a refugee who had suffered from domestic abuse, I challenged that policy on Article 14 grounds successfully, and as it happened in the Inner House. I think those are the two that, and I suppose that's not that I suppose the differentiation there wasn't to do with race. It's more a general point about Article 14 and my awareness of that article.
Did you have any experience of criminal cases, criminal investigations, where race or racial motivation had been a factor or a potential factor?
I have a recollection when I was Advocate Depute of prosecuting one, I think it was a homicide, it was certainly a case that involved the death of an asylum seeker, and I can't now remember the details of it, but I think there may have been issues of race involved in that. But that was a case that as far as I can recall, I probably, as it were, picked up for trial rather than being involved in the investigation in advance. I've dealt with some asylum cases, but they're not particularly cases that involve issues of racism.
All right, thank you. Could we look now at paragraph 122? You were commenting on your involvement with this investigation. You say, I do not recall any consideration being given to Article 14. And I wondered whether you recall any discussions amongst or with your staff when you were Lord Advocate about Article 14 and the implications of Article 14 in conjunction with Article 2.
I certainly don't remember any. I think, as I said before the break, my experience of Crown Office, and certainly over the piece as Lord Advocate, was that it was, staff were, it was an organisation that was very alive to a whole range of issues of equality and inclusion, both internally and externally. Looking at this with hindsight, I assumed that the experienced staff who were involved in a case that where there was an issue of race would investigate that as part of the investigation.
You've said you assumed they would take account of race. Did you take any steps personally to ask if they were taking account of these issues or having regard to these issues, or specifically ask them if they would have regard to these issues?
I suppose this goes more generally to my the role that I had as the investigation unfolded, and it would be fair to say that I relied on the investigative team that was set up in accordance with the minute that Stephen McGowan sent to me, and which we've seen, to investigate the case appropriately. Now, of course, that doesn't in the least take away from my responsibility for what's being done. I don't recall myself interrogating the way in which they were approaching any particular issue. I don't recall, although there's some evidence that I may have had meetings with APCC. Don't recall those. She may have a better recollection. I recall a particular anxiety that I had at one point about the time that the whole process was taking, and interrogating that both with the Crown Agent and also a meeting with Mr. Brown in my room in Crown Office. But as far as I can recall, that was focused really on issues of management and timescale rather than the substance of the investigation. And I was receiving regular briefings as part of the LOB about, as it were, progress at the generality. I did not take steps to as it were, scrutinise the substance of the investigation. That might be regarded as a missed opportunity. On the other hand, I had a very experienced senior Crown Counsel with frankly, much greater experience of criminal investigations than I did, who was allocated to the case, who had all the powers and responsibilities of the Lord Advocate, it might have been regarded as was it necessary for me to, in a sense, oversee her work in that regard? With the benefit of hindsight, of course, one can say there's a missed opportunity to ask questions, but I relied on that team. That's the context in which I'm ultimately responsible for the decision made. That as I say in my statement, Lord Advocates have to deal with the situations as they come along across the whole range of their responsibilities. The extent to which they get any individual Lord Advocate becomes personally involved in any particular issue will depend on the range of competing demands, the particular pressures, but ultimately the Lord Advocate is answerable for the decision to take an active role or not to take an active role in an individual case. That's one of the challenges of that particular particular office. And I suppose in this case, I took the view that I had a experienced team allocated. There was oversight in a sort of general sense from senior Crown Office officials, very experienced prosecutors themselves, and that if there was an issue that required law officer focus or attention, that would be brought to the law officers. And my experience across the piece was that if in relation to a particular case there was an issue that needed to be brought to law officers' attention, then it would be brought to their attention. Now, so to that extent, I suppose I relied on the system, I relied on the particular, as I say, highly experienced individuals who were in place, and I didn't ask, I didn't seek to, as it were, second guess or exercise a kind of oversight of what they were doing.
So in relation to your role as Lord Advocate, you've talked about the Lord Advocate having essentially a decision to make whether to take an active role or not an active role. Is it fair to say that in relation to the Shekau investigation, that you did not take what you would describe as an active role in relation to the investigation itself, but rather left that to a large extent to the team that had been put together to deal with the investigation?
I think the phrase "left to" is perhaps to diminish the expertise. But my responsibility was to put in place arrangements to have an effective, thorough investigation. The starting point for that is a skilled and experienced team who undertake that investigation, and there were other large significant cases ongoing. I had I had the same role, as it were, internally in relation to other large and complex cases. The nature of the work in Crown Office very largely is that the investigative work is undertaken by those who are undertaking investigations with the input of Crown Counsel as required. As head of the system, my responsibility was for the whole system, and I don't think it would be right to say that I took a conscious decision in relation to this case not to play a role. In fact, I had a more active role in this case than for most equivalent cases, in part because of the interaction with the Mr. Bayo's family and Mr. Correspondence with Mr. Anwar. So I think it would be right to say this case, as it were, came, as it were, actively onto my radar more often and more than other large, complex, significant cases. I mean, the great bulk of the even the highly sensitive cases undertaken in Crown Office don't come to onto law officers' desks. Or at least in my time, that was the position. It may be different with other Lord Advocates, and that's also a reality of the role. That different people, the way that they approach the role, in all sorts of ways, may ultimately reflects both the exigencies of the times and the pressures that bear at different points in time, and the judgment and approach of individual incumbents.
Specifically in relation to the issue of race, although you recognised the significance and importance of race, and we've talked about that, is it fair to say that your approach regarding race, insofar as it related to the investigation to Mr. Bayo's death, was not to take proactive steps or not to take a proactive role in relation to how that investigation was managed and conducted and ultimately resolved?
I think that would be right, in the sense that I relied on the experienced team to undertake an appropriate investigation.
Thank you. Now we've touched on paragraph 1, 2, well actually 1, 2, 3 first of all. To what extent was Article 2 of the ECHR considered in the investigation in respect to the duties of Police Scotland and PERC? And you said at 1, 2, 3, I do not recall being involved in any consideration of Article 2 ECHR in respect to the duties of Police Scotland and PERC. The involvement of the PERC in the investigation provided structural independence from Police Scotland given the circumstances of Mr. Bio's death. We've heard evidence from a number of witnesses in relation to the independence issue, so I won't ask you questions about that today, but I'm interested about in this paragraph, I do not recall being involved in any consideration of Article 2 in respect of the duties of Police Scotland and PERC. Are you talking about you personally, or are you talking about discussions amongst the team that you're aware of, or raising any issues about Article 2?
I can't really go beyond. I simply don't recall any discussions of that sort, and I don't recall myself being involved in them. I don't recall being made aware of them. That's frankly not to say it didn't happen. It's just that I don't have a recollection of the issue.
Can we move on to 125? And we've touched on this today, so I don't want to go into this in too much detail. But I'm interested in the section that starts, I also acknowledge, of course. And you'll see that's just below halfway down this paragraph. I also acknowledge, of course, that a deficiency in a Crown Office investigation, do you see that?
Indeed.
In a case to which Article 2 applies, would be capable of contributing to a breach of the state of its Article 2 obligations. For example, if the way in which Crown Office proceeded with an investigation were to justify or to contribute to a conclusion that it had not proceeded with reasonable expedition, it follows that issues can arise as an investigation is ongoing as to whether anything done by the Crown is such as to breach Article 2 ECHR in any particular case. Can I ask you about the processes that were in Crown Office at the time you were Lord Advocate? Was there any process whereby Article 2 obligations, or indeed Article 14, were monitored? Or you used the word earlier before the break of auditing. You said you didn't personally audit Article 2, but I'm interested in whether there was a process within the wider Crown Office staff whereby even sampling investigations to look at them from the perspective of whether they were compliant with convention obligations.
I don't have any recollection of such a process. I mean, it's fair to say that at this time, specifically in relation to death investigations, there was just a real problem of a overstretched system that was across the piece, taking longer than one would want to see in relation to death investigation. Of course, not every death investigation engages Article 2, but they tend to be the more complex ones, and those in particular were taking a very long time. I don't know whether there was a process of monitoring against time. Well, actually, I suppose what I became aware of in relation to the work of SFIU, but probably a slightly different point, was that the KPI, the key performance indicator, was for a certain proportion of the cases, and I can't remember the detail, to be concluded within quite a short time scale. Now, the consequence of that particular KPI was that the system focused on completing the investigation in those which were relatively straightforward, with the result that the more difficult ones became there was a potential for them to take even longer. Now that was part of the modernisation, SFIU modernisation project that I think I touched on yesterday, was about addressing both you know, the having the appropriate as it were, KPIs and auditing and oversight of death investigations generally. And also, and absolutely critically, because it couldn't be done without it, was securing quite significant additional resources in order to do that. So I think, and you would have to ask others. I mean, I suspect Lindsay Miller, who I think you've already had, would have been a good person to ask about, you know, what were the KPIs, what were the, you know, what were the you know, what was the process of auditing in that sort of management sense. You know, I, as Lord Advocate, would not necessarily be aware of those routinely, because, you know, as you'll appreciate, Lord Advocate's not, you know, it's an unusual role in that you're not really the chief executive managing in that sense, but you have an overall responsibility for the system, including Crown Office's performance within the system, and one is, you know, one wants to be informed about you know, ideally the way the Crown Office is fulfilling its functions.
Leaving aside the issue of the system being overstretched or issues of resources, of which we've heard some evidence already, do you think there would be any benefit, having been Lord Advocate, can you see any benefit in doing some sort of, or introducing some sort of audit process whereby Crown could pick up issues as they are happening, and whether those be issues relating to delay or independence or adequacy? Could you see any benefit in a system that assessed things as the investigation was ongoing?
Well, I think any organisation benefits from a process of having appropriate targets, indicators, and auditing its performance against those targets and indicators. And I mean, this is I suppose, reflection born of experience of being Lord Advocate and in other roles, that you know, part of the you know, one of the ways one achieves change is by thinking hard about what are the right indicators and targets to put in place, addressing any issues of resourcing that need to be put in place in order to achieve those targets, and then auditing against you know, auditing against the targets to assess how the organisation is performing. And I suppose, just sorry to again just reflecting on it, one of the things that the SFIU modernisation project put in place, as I recall it, was a process of as it were, internal oversight of investigations, which ensured that, you know, at appropriate points there was a review of where an investigation had reached and whether it was how it was continuing. Precise details, I'm afraid, I now don't remember, but, you know, that was as it were, a new process put in place after this case. Wouldn't have, you know, it was specific to SFIU, so you know, I can't say whether this case would have proceeded in a different way had that been that sort of system been in place, or indeed whether, you know, given the role of senior Crown staff like Lindsay Miller and Stephen McGowan, whether, you know, in a sense that oversight was there.
All right. And from what you've said, you don't know if those key indicators related to Article 2 obligations, do you?
I don't think they were not specifically focused on Article 2. Whether there was any process at that time of picking up and identifying the cases to which Article 2 applied, I'm afraid, again, I can't can't say. I suspect not. I suspect there was a there was an appreciation. I'm pretty confident there was an appreciation, particularly within SFIU and by Ms. Miller as the DCA of the role of Article 2 in death investigations. Just how that was brought to bear in across the caseload, I'm afraid I can't say.
Could we move on, please, to paragraph 129? Mr. Bayo's race was not a factor in any of my decisions or actions, except to the extent that the allegations of racism on the part of the police was an element in the circumstances prompting greater than usual law officer involvement in this case. Sorry, I should perhaps have said the question you were asked was to what extent was his race a factor, and you've said it was not. When you were Lord Advocate, did you consider, or were there any discussions with your staff or discussions that you're aware of in Crown Office about whether the investigation into the death of Mr. Bayo effectively investigated the death of Mr. Bayo in the same way that Crown Office would have investigated the death of a white man who'd died in police custody or after contact with the police?
I have no recollection of any such discussion, but I would be I would be astonished if there was a difference in approach, other than, of course, that the issue of racism and potential impact of race on the on the circumstances would be something that would need to be factored in the context of a black man as opposed to a white man. So I mean the basic, as it were, the basic principles of independence, thoroughness, investigating the issues that needed to be investigated would be the same, I would have thought, but one would have to include into that the question of whether race had played a role in the death, and that would be true as a matter of general just the proper investigation of the circumstances of the individual case in the public interest, and also because of Article 14.
We've heard some evidence, and we may hear further evidence about this issue at a subsequent hearing, a later hearing, that about the issue of whether treating everyone the same and doing the same thing across the board is a sufficient and adequate approach to avoid discrimination, and whether it may be an issue for the chair that whether the application of Crown Office policies and strategies regarding investigations had any indirect discriminatory effect. And so those may be issues that we will explore further and may hear further evidence on. But when you were Lord Advocate, did you consider whether this incremental, linear, sequential approach that we've discussed yesterday and this morning had any impact in relation to the particular circumstances that were faced by Crown Office in relation to the death of Mr. Bayo, who was obviously a black man?
Yes, absolutely. I don't recall, as I'm afraid, the answer. Absolutely recognised and would have recognised at the time that that treating everyone the same may not be either legally or morally correct if one's not taking proper account of differences, and that specifically in the context of race, that one may need to look at one has to, as appropriate, factor that issue in to whatever process one is concerned with. So I recognise absolutely that Article 14 both requires you to treat like cases like, but also to treat different cases with appropriately differently, and that ultimately, I suppose, is the issue that you're foreshadowing.
So do you remember personally giving any consideration to the issue of whether this incremental approach to the investigation into Mr. Mayo's death could indirectly discriminate, whereby that approach, that sequential approach, did not perhaps address all the issues regarding race or racial motivation from the very beginning?
Yes. I mean, I think the only point at which I would have considered the issue in the way that you've described is there was the minute from Stephen McGowan, which was seeking, in effect, law officer approval of in effect, at the very high level of the team that was being put in place, and that minute clearly proceeds on the basis that what was envisaged at that stage was a criminal investigation. I would have, frankly, I would have proceeded on the assumption that race would be considered in the context of that criminal investigation to the full extent that it was relevant. And I think we looked at a passage yesterday in my statement where I said I had no preconception or presumption about how that, what that would be, and I assumed that it would be.
When you've talked a number of times about making these assumptions in relation to how race was going to be, or the investigation into racial motivation was going to be explored within the team, can you provide the chair with some explanation of why you felt comfortable making these assumptions?
Yes, I suppose two factors. First of all, what on the face of it was and I think from my experience of them in actuality, a highly experienced team was put in place in the shape of Mr. Brown and Mr. MacLeod, very experienced procurator fiscals, whom over the course of my time, I don't think I knew them previously, but I dealt with on a number of occasions, with the oversight of one of my most experienced prosecutors, in the context and with demonstrable, as it were, input and oversight, at least as I perceived it, from Deputy Crown Agent Ms. Miller. I knew that she was, for example, meeting with Mr. Anwar, and I can't remember just precisely when Stephen McGowan's role, he was involved at some point, but there were senior Crown Office
We've
staff.
heard he was involved from the beginning.
And I think I mentioned this earlier, my experience of Crown Office was that it was an organisation that was exceptionally engaged with issues generally of equality, inclusion and exclusion, which is the other side of inclusion. I saw that that commitment myself by attending the internal staff equalities conferences, which brought together staff from across the whole service who were champions or ambassadors, I can't remember the term, within the organisation for equalities and inclusion. There were various staff networks, but the whole ethos of the organisation was extremely, in my experience, engaged with those issues, and externally. There was engagement with external organisations, and also a strong commitment, for example, in relation to hate crime, which was both expressed publicly and so far as I could see was the reality of the way the organisation approached issues. So in a sense I can't say this played into my thinking at the time, but in terms of making to the extent that I'm relying on the professionalism of highly experienced professionals in a context of a case that raises issues about race. I'm doing so in the context of an organisation that I am experiencing as an organisation that is across the board interested in, committed to taking active steps to promote internally and externally an inclusive and thoughtful approach, led at that time, I think, by, as I recall it, by John Dunn, who was the senior deputy Crown agent.
And having made these assumptions, did you personally take any active steps to check, to reassure yourself that the issue of race and racial motivation was being properly considered by those members of staff that had been appointed?
No, I didn't. I mean, I think I made the point before we broke that I received, as it were, reports on progress. In this case, as in other cases, expected that if there was an issue, a particular issue that required law officer personal engagement, that would be brought to me, and there were various different points in the system where that might be triggered. But I didn't proactively take any steps to ask that question.
Thinking about the processes and procedures, policies that may have been available within Crown Office when you were Lord Advocate, are you aware of any policies which would have prompted staff in some way who were involved in this period of investigation to consider issues of racism or racial motivation? Now I'm thinking either of templates or some sort of other prompt.
I'm simply not aware, or certainly don't recall.
Can I move on to a separate issue, in particular the Health and Safety Executive? Could we look at paragraph 55, please? Now, we've heard some evidence about the Health and Safety Executive from witnesses to the inquiry, and here you talk about HSE as the agency with general responsibility for the regulation of health and safety at work, including investigating potential breaches of the Health and Safety at Work, etc. Act 1974 and/or health and safety regulations. It is a specialist reporting agency, i.e. it may itself report cases to Crown Office for consideration of prosecution. Generally speaking, it would be for HSE to determine its regulatory approach to breaches of health and safety law, including the balance to be struck between enforcement through reporting cases for prosecution and other regulatory mechanisms available to it. However, there is nothing in principle to prevent Crown Office itself from investigating a potential breach of health and safety law, even though usually Crown Office would leave the investigation of such cases to the Health and Safety Executive. By contrast with the position with the police and the PERC, the prosecutor has no power to direct HSE to investigate a particular matter, and accordingly, if HSE declines to take up a case, Crown Office requires to rely on the police, the PERC, or work undertaken by Crown Office itself to undertake the investigation. I note that in this case there was in fact a supplementary report to Crown Counsel addressing the question of whether there had been breaches of health and safety law. So I cannot say that the involvement of HSE would have made a difference in this particular case. I'm less interested in what the potential outcome may have been, but I'm interested in the setup which existed between the Crown and HSE. And in particular, the idea that the prosecutor within the Crown Office does not have the power to direct what you recognise were specialists in this field to carry out an investigation. Now, we've heard evidence, and there is other evidence available to the chair, that I think PERC would have welcomed the involvement of HSE in relation to the death of Mr. Pyle. And my understanding is that the Crown also would have welcomed the involvement of HSE. But HSE declined to become involved, and as Lord Advocate, you did not have the power to require them. And I'm interested in any reflections you have on that, and obviously thinking, would it have been helpful to have had the power to involve them?
This isn't the only case where I would have welcomed the power to direct the HSE or to require their involvement. I mean, there is a constitutional context, of course, where the police, for historical reasons, act ultimately under the direction of the Crown, and that's been replicated in the PERC and also in so far as the National Crime Agency operates in Scotland, but it doesn't extend to specialist reporting agencies across the piece, of which there are many. The HSE is only one. So that, there's a particular constitutional context, but it certainly I mean, it would be from the perspective of the Lord Advocate as head of the system. This, as I say, this is not the only occasion where it would have been useful to be able to require the HSE to be involved.
And in relation to, obviously, the Crown Office, we've heard that there is now a health and safety unit which specialises in health and safety matters.
And I think there was in my time.
In your time.
And I think Mr. MacLeod, certainly later on, was head of that unit, if I remember correctly.
I think Mr. McGowan gave evidence that that unit existed, and certainly there was a supplementary recognition in relation to the issue of health and safety.
Yes,
I'm
and indeed, sorry, Mr.
sorry.
Graham, and indeed when we looked at the interactions between myself and APCC, I think one of the points which I'd asked for further work to be done on was the question of whether there was a potential health and safety at work breach, which was not causally connected to the death of Mr. Bayou. I suspect, again, I haven't gone back to the original documents. I suspect the initial consideration of this was very focused on a potential health and safety at work breach causally connected to the death, and I think if I read the documentation I saw correctly, I'd asked for some work to be done to look at whether the circumstances disclosed a health and safety at work breach which didn't necessarily have a provable causal connection to the death, but which nevertheless emerged from the evidence that the Crown had.
You've clearly said you would have welcomed their involvement in this matter. I wonder, can you assist the Chair by explaining or giving an example of the type of things that caused you to form the conclusion that it would have been welcome to have the HSE involved?
Well, it's there in the statement. I mean, they're an agency with statutory responsibility for regulating health and safety at work issues. It follows that they have a body of internal experience and expertise, and also, and this is why I think there is probably a question which, you know, a power of direction would raise, because they are a regulator of health and safety at work, obviously across the piece, and they have a variety of regulatory powers. It's the nature of a regulatory body that they calibrate the use of their powers and their intervention according to their own judgment. So, you know, and I don't know whether this applies particularly to the HSE, but I'm conscious in other regulatory contexts that one has to make a judgment about how far to use prosecution and enforcement and how far to use what one might call encouragement and more soft approaches to regulation. And, you know, it is the HSE that across all areas of health and safety at work is statutorily charged with making those judgments. Lord Advocate's interest is obviously a very particular one in relation to the investigation, prosecution of crime and investigation of deaths.
So in relation to the Crown Office Health and Safety Unit, the Chair should not consider them to be in the shoes of, or in the same position as the HSE, because that's full of lawyers, not investigators. There's no regulatory powers within that unit, and there's no enforcement powers available within that unit.
Well, other than prosecution.
Other than
ultimately,
prosecution.
Or in a death case, to hold a fatal accident inquiry. Of course, you know, the Crown has available to it the power to direct the police, and I can't remember which case it was, but I do have a recollection of a case where the HSE had been declined to be involved, and I can't remember whether I directed it or I was certainly aware of it, where the Crown basically was directing the police to carry out an investigation. But of course the police are, as it were, investigators of crime across the whole piece and are not specialists in the specifics of health and safety regulation.
That's something in the hands of the HSE.
Yeah.
We touched on something yesterday in relation to disclosure and the approach taken to disclosure, and I'd like to go back to that briefly to ask one matter. Could we look at paragraph 64? And I think it's halfway down the paragraph. You say, although I had reservations. Do you see that in the middle of the screen?
Yes.
Although I had reservations as to whether the earlier disclosure had been sound, I accepted Mr. Brown's advice that the existing commitment or understanding should be honoured, and that if there were any further reports falling into that category which had not yet been disclosed, these should also be disclosed. So this related to the issue of the disclosure to the family,
Yeah.
and the comparison between the approach taken by Frank Mulholland when he was Lord Advocate and the approach taken by you, and I think you explained that. But can I ask, where you say, although I had reservations as to whether the earlier disclosure had been sound, can you explain what those reservations were?
And I think, as far as I can recall it, I was told that a view had been taken that Article 2 required disclosure. And I wasn't convinced that that was correct in the context of a criminal investigation, at least where there was any risk of prejudicing future criminal proceedings. But there was no, I mean, at the point where I was considering the question that came to me in February or March, I can't remember precisely when, there was no point in me, as it were, revisiting that. That had been done. At least at that point I had taken it, it had been done. The only question for me at that stage was, what's the appropriate thing to do now with the issue that was before me, and it was only at a later point that the question of the previous understanding or commitment, however one, whatever it's properly understood, came to the fore in the way that it is described there.
When you talk about risks to, or your concern regarding risks to future criminal proceedings, could you help us understand what you viewed those risks as being?
I suppose it goes back to the general point that, you know, the Crown is always concerned that about the risk, the potential for its investigation to, or matters that it's looking at in the context of its investigation to those are disclosed to give rise to possible questions of prejudice. The Crown has a responsibility and needs to be able to investigate, as it were, in a private space, reach its conclusions and then take whatever course is the right course.
Were your concern? Oh, sorry.
I mean, I suppose one risk, and this I think I think it would be an interesting and possibly important thing for this inquiry to reflect on. One risk in the context of a possible criminal prosecution of police officers is questions of the Crown has to be independent and demonstrably independent. Questions, one would not want to end up with a position where it could be said or any issue could be raised about the as it were, the independence of the Crown's investigation, regardless of how that might have been affected. And I suppose what one might be concerned about would be that if, for example, it's the proposition is that there's let's say one went to a position of very open disclosure to any party that's taken away from this case, and taking views about how the Crown should proceed with its investigation and so on and so forth, issues about how that would be perceived down the line in the context of a criminal prosecution and trial, where that's not been tested out and considered by the courts, so far as I'm aware. So there's an issue about ensuring the independence and integrity, and that's not to cast any aspersions on anyone at all in the particulars of this case. How that might be viewed down the line. So that's a very general point. As I recall it, there was, at least when Mr. McGowan gave me some very high-level advice about this at an early stage, he made a point that some members of the family might well be witnesses, and again, there'll be an issue about potentially, I suppose, about disclosure of information to witnesses. So there's a set of questions in a context of a background where the Crown has, I think for good reason, always been pretty careful about the way that it approaches investigations. And I think I also, to some extent I'm having to reconstruct my thinking. I would be alive to the need to not take a step that couldn't be generalized appropriately to other cases. So however, in a sense, whatever the leaving aside this case, if we were to take the same approach, if one were to take the view that it was an obligation under either Article 2 or potentially under Article 3 to disclose the Crown investigation on an ongoing basis to the victim of a potential crime, the complainant in a complainer in a Article 3 case, or the family in an Article 2 case. How does one draw a line? I think I would be conscious that to take that step is to create a system which would be very different from the system that we currently have, and that one had to be careful not perhaps in a very sympathetic case to take a step that would pose challenges in other cases.
So the concern, or part of the concern, was around disclosure to the family, and ongoing disclosure to the family may have an impact on how the Crown's independence was subsequently viewed at later proceedings.
Potentially.
And was that explained to the family, that was part of this reasoning behind the changed approach to disclosure?
You'll be able to take me to the letter. There was an exchange of correspondence with Mr. Anwar, and I'm pretty sure that explained that there was a general concern about the potential of prejudice to future proceedings. It may not have gone into more detail, and I've already reflected in my statement that I think there was, again, perhaps a missed opportunity in terms of just the way that the issue unfolded in relation to meetings with the family, and be able to explain why that particular decision was taken in a way that was as better able to be a constructive exchange than I fear proved to be the case.
I'd like to move on actually to your involvement with the family, if I may. Could
Yes,
we
of course.
begin by looking at paragraph 58 in your statement? You were asked about your involvement, and you said, "I had 2 meetings with members of Mr. Bio's family. I can see from the documents provided to me that the first of these meetings took place on the 8th of February 2017 and the second on the 3rd of October 2018. I refer to these meetings further below. I was from time to time made aware that prosecutors involved in the investigation were meeting with Mr. Anwar and the members of Mr. Bio's family, but these meetings took place without reference to me. I explained my involvement in deciding what to disclose to Mr. Anwar below." We've touched on that. Yeah. So you had 2 meetings. We've heard that the 3rd of October 2018 meeting was the one after the decision had been taken, the prosecutorial decision had been taken. Was the first time you met the family on the 8th of February 2017? I think you mentioned this yesterday.
As far as I recall, that was the first time I met with them. And in fact, I'm confident from looking at the documents that was the case. And I think looking at the documents that, and I'm not sure if I suppose they're documents that were, if I've seen them, came up to my office, but I'm not sure if I would have been particularly picking this up at the time, that there had been discussions between Miss Miller and Mr. Anwar about, when would be an appropriate good time for me to be introduced to the family.
Right. Let's look at paragraph 109. I think that this is the part of your statement where you address this meeting. So that's 109. Here we are. With hindsight and with the benefit of experience, including my experience of this case, there are a number of steps which I could have taken which might have mitigated the position. In meeting in February 2017, the meeting in February 2017 could have been better managed. Expectations about timescales, roles and responsibilities, processes, and access to information. I could have asked subsequently for a meeting in order to explain why I had decided not to disclose the product of the Crown's investigation as the investigation was ongoing, rather than dealing with the matter in correspondence. The February 2017 meeting was, as I understand it, set up following discussions between Mr. Anwar and Crown Office staff. And so far as I can recall, there were no requests from Mr. Anwar for further meetings except to discuss, advise the family of the outcome of the investigation. But I could, particularly as the duration of the investigation became much longer than I had initially anticipated, have been more proactive in seeking to ascertain what the family, advised by their solicitor, would wish by way of interaction with the Crown, including further meetings with myself. Whilst none of these steps would necessarily have mitigated the family's disappointment about the outcome of the investigation, they could perhaps have made a difference to the family's confidence in the process. So, February 2017 is the first meeting. You have been in post since the 1st of June 2016. Why did it take that period of time to have a first meeting with the family?
I'm not sure that I can. I'm not sure that I know the answer to that. I mean, as I say, I was aware of. I think there may have been two issues. Well, actually, I'm not sure I can answer that in any great, with anything concrete. That I certainly have no recollection from the time. From the documents, there was clearly some engagement between Mr. Anwar and Crown Office, and this was back in at some point late in 2016. I think on the back of an exchange of correspondence where Mr. Anwar had written to me, in effect, inviting a potential meeting, and I wrote back. And then there was, if I read the documentation correctly, there was then some discussion between him and Lindsay Miller about timing. Mr. Anwar asked for a particular date, which for particular reasons were, wasn't the date that was fixed on, but the meeting that was held was around, I think, the date that he had requested. So I'm sorry, I'm not trying to suggest that it's should be solely for Mr. Ultimately, I should, one might say, be thinking about this, but I suppose there'd been an exchange of correspondence, an acknowledgement on my part that that it would be appropriate to meet the family at a certain point, and then a discussion between Mr. Anwar and the Crown about when that point would be, is how I read the material.
Right. I think we'll come back to this later, but I wonder if that would be...
We'll stop for lunch now and sit at 2 o'clock.